So you have watched my video about when a financial power of attorney, durable power of attorney, or statutory does not work. Now let's talk about the situation when a medical power of attorney does not work. My name is Megan Trewick, lead estate planning attorney here with the law office of Bryan Fagan. I deal with probate, guardianship, and estate planning. So your wills, your trusts, all the good work. And therefore I have very, very extensive experience when it comes to medical power of attorney. And therefore, when does the medical power of attorney not work? The medical power of attorney does not work, one, if it's revoked by the principal that gave it to you. So the person who gave you the power of attorney says, you know what? I don't like the way you make decisions, and therefore I'm going to terminate your position as my medical power of attorney. And they rip up the power of attorney, or they send you a text, or they give you a phone call, or they write you a letter. However they made you know that you're no longer their medical power of attorney, that's it. A medical power of attorney is revocable. I've seen many situations wherein, especially older people, will give somebody their medical power of attorney, and they will change their minds, take back their medical power of attorney, or say you're no longer my medical power of attorney, and then they go to the hospital. And the person whose power of attorney they've revoked show up at the hospital, and the hospital is treating my elderly client as if they're not a real person, not a full person, and cannot say, no, I don't want Sue in my medical area. I don't want Sue in my room. I've terminated her medical power of attorney. I've seen so often where my clients' rights are being infringed upon, and I have to step in and I have to say, whoa, this is a revocable medical power of attorney. Miss Jenny says she doesn't want this lady in her room. She has the right, she has the autonomy over her own body. She just revoked the power of attorney. This medical power of attorney is no good. So you have the situation where it's revoked. Another situation is when the medical power of attorney is a springing medical power of attorney, which means that yes, you have medical power of attorney, but only when the person is incapacitated. So usually it's two doctors who have to say, yes, this person is medically incapacitated, or it's so clear the person is in a coma, incapacitated. There's no way that you can misconstrue the fact that the person lacks capacity at the time. Then that medical power of attorney springs into life, and you can make decisions for that person according to that medical power of attorney, according to their directive, until the person regains capacity. Another time while the medical power of attorney does not work is, you guessed it, when the person is deceased. You cannot have power when you're deceased. And therefore, if you can't make decisions for yourself because you're deceased, your POA, your medical power of attorney, cannot make decisions for you. They can't use that medical power of attorney to gain your medical records. They can't use that medical power of attorney to get your death certificate. They can't use that medical power of attorney for anything, or I should say, they can't legally do that because you're deceased. So please, people, stop using medical powers of attorney if the person is deceased. That's illegal. Please don't do it. My name again, Megan Trewick. Thank you for watching. If you just watched that video and you like it, please remember to click the like button. And most importantly, if you want to see more videos like this, go ahead and subscribe so that you can get the top of the line, most up-to-date information on our new posts. Thank you for watching.